When will the Russian dictator Putin and his entourage be imprisoned for numerous war crimes? Genocide and terror against the Ukrainian people. Anton Korynevych, Ambassador at Large of the Ministry of Foreign Affairs of Ukraine. Anton, congratulations. Before the BRICS summit, the illegitimate Russian dictator told journalists that the International Criminal Court is not a universal organization. He was told, "Come on," and he shut up. That's how some presidents talk now. What would the International Criminal Court... say? This is a legitimate organization, and Putin will not tell them otherwise. First, let's wait for the summit in Brazil. It's crucial that the Russian Federation is not represented at a high level, as Vladimir Putin has an arrest warrant from the International Criminal Court for the illegal deportation of Ukrainian children from occupied territories to Russia. This means that under the provisions of the Rome Statute, all member states that are parties to the Rome Statute have an obligation to detain this person as soon as he or she is in their jurisdiction, including on the territory of the respective state. So, of course, let's hope that, just like last year in the case of the African Republic, the state will respect international law and fulfill its obligations under the Rome Statute. This will prevent the Russian dictator from traveling freely around the world and attending important international events. I would add that the Rome Statute requires the detention of a person who has an arrest warrant from the ICC is absolute. No legal argument can justify the failure to detain such a person. Anton, when Putin says he won't go to Brazil for the G20 summit, he claims he doesn't want to politicize the event, but he is actually afraid of being arrested under the ICC warrant of March 17, 2023. Thank you for reminding us about the illegal deportation of Ukrainian children. By the way, Brazilian President Lula da Silva is also not going to the BRICS summit in Russia. Putin says that the Russian Federation will be represented at the highest level. We can send signals to Brazil that Russian criminals should not be present there because they are not officially recognized. If they do show up, what are our steps? As an international lawyer, I believe it is important to explain that the issue of the arrest warrant is not politicization, but the fulfillment of international obligations. This is a legal issue, so the question of detention arises when a person is in the territory of a state party to the Rome Statute of the International Criminal Court. Any talk of politicization certainly has nothing to do with international law. We hope that major regional players, states, will respect their obligations under international law. As for the other individuals from the Russian Federation, we have 6 arrest warrants from the International Criminal Court against citizens of the Russian Federation: Vladimir Putin, Maria Lvova-Belova, Sergei Kobylash, Viktor Sokolov, Sergei Shoigu, and Valery Gerasimov. Accordingly, any of these 6 individuals who enter the territory of a state that is a party to the Rome Statute should be detained immediately, without any further explanation or justification. Again, no other legal argument can justify the failure to detain this person. As for persons who do not have ICC warrants, the host country is not obliged to detain them. However, other mechanisms exist, such as international criminal assistance and political mechanisms. Diplomats dealing with this situation are doing their job and will eventually complete it. This issue is not just about Ukraine. This is also important for the International Criminal Court and the entire system of international law. ICC arrest warrants must be respected and executed. A person subject to an ICC arrest warrant must understand that his or her life will never be the same again, as he or she is a presumptive accused of an international war crime. Accordingly, he or she should be handed over to an international criminal justice body when he or she comes under the jurisdiction of a state that has ratified
І, відповідно, вона має бути передана органу міжнародного кримінального правосуддя.
The Rome Statute.
Вона потрапить під юрисдикцію держави, що ратифікувала Римський статут.
The life of these non-humans is not as frivolous as they thought. Anton, I remember when Putin went to Mongolia on September 3rd, ruining my birthday. At the time, we were worried that this could be a dangerous precedent because Mongolia is a party to the Rome Statute and he was not arrested there. This Mongolian precedent may lead Putin to hope for similar things in other countries, where he will be welcomed with carpets and fanfare. Why is this dangerous? What did Putin want to demonstrate? He is actually ignoring international law by doing this on our territory since 2011. I think it is important to look at this issue from the perspective of international law, as it is the key in this situation. Mongolia has violated its obligations under the Rome Statute as a state party to the International Criminal Court. Again, you can try to look for political justifications. Look at the physical and political map of the world regarding the location of a particular state. But if you are a member of the ICC and have voluntarily decided to participate in it, you are obliged to comply with all decisions of the International Criminal Court, including arrest warrants. Therefore, Mongolia has certainly violated its obligations under the Rome Statute. The Ministry of Foreign Affairs of Ukraine responded appropriately to this situation, including by expressing disagreement with its Mongolian counterparts. We hope that the issue of Mongolia's responsibility for such actions will be discussed in December this year. From December 2nd to 7, Gaza will host the next annual Assembly of States Parties to the International Criminal Court, where such issues can and should be discussed. We hope that during this assembly, Mongolia will feel all its wrongness in the political and legal sense. It is important that the situation with Mongolia does not become a precedent. This is in the common interest of the International Criminal Court, as its decisions and warrant are key to international justice. Respect for law and the rule of law are fundamental international relations. I hope that the case of Mongolia will remain unique and that there will be no such situations in the future. We need to work because Russia may try to use this experience. As you mentioned, on September 12th, Ukraine's ICJ announced a démarche to the Mongolian side over Putin's visit, saying that Ukraine would respond to such actions.
Більше таких ситуацій, і цей кейс, він не стане прецедентом. Звичайно, для цього теж треба багато працювати, бо ми розуміємо, що Російська Федерація буде намагатися масштабувати цей досвід.
What are the practical consequences of punishments and sanctions against Mongolia? A judge from Mongolia was present when Putin arrived at the ICC. How will they be held accountable for violating international norms? This issue can only be discussed at a meeting of the Assembly of States Parties, which I hope will be on the agenda in early December this year. We will follow the discussion of this issue at the Assembly of States Parties to the ICC. As for the ICC judge from Mongolia, his personal activities during his appointment have no direct connection with the state. Therefore, there are no legal consequences for the judge. However, this is not the main point, since Mongolia is a state party to the ICC, not a Mongolian citizen working at the International Criminal Court. I think it is very important that the issue of Mongolia's non-compliance with its obligations under the Rome Statute be raised as loudly as possible at the Assembly of States Parties in December this year. And to make Mongolia realize the wrongness of its decision. You mentioned that not only Putin and Maria Lvova-Belova, but also other representatives of the Russian military and political corps, such as Shoigu, Gerasimov, Kobylash, and Sokolov, have ICC warrants. In June, Shoigu and Gerasimov were added to the list. What practical limitations do they face now? What kind of liability do they face until these warrants are implemented? How much does this bother Russian war criminals? I think that, first of all, the very fact that the main body of international criminal justice today considers you an alleged war criminal should show both this person and the international community that these people are not, as they consider themselves, conventionally quoted heroes or something else, brave Russian soldiers, officers, generals. They have put a bunch of so-called stars and everything else on themselves. In fact, they are war criminals. They are no different from those who were held accountable, say, at the Nuremberg and Tokyo trials. So I think that for the historical question and for what these people will remain in history, not only in a history textbook published in the Russian Federation, but for the world as a whole, I think it is important. That is, you are not a military leader, but a war criminal. These individuals are subject to the same restrictions. They cannot freely stay on the territory of states that are parties to the Rome Statute. As long as they remain in Russia or travel to countries that have not ratified the Rome Statute, the ICC cannot detain them, as these states are not obliged to arrest them. But if such persons at some point in time, maybe today, maybe tomorrow, maybe the day after tomorrow, may be on the territory of 124 states, Ukraine will soon become the 125th state party to the Rome Statute. So these 124, soon to be 125 states have a direct obligation to detain these individuals, and they will immediately be brought to The Hague and placed at the disposal of the International Criminal Court for trial. So, as long as they are on the territory of the Russian Federation, they may temporarily, relatively, not feel the results of these arrest warrants. But the clock is ticking, and of course anytime they stay, anytime they visit the territory of 124 countries, different regions of the world, not only Europe but also Asia, Africa, South and Central America, these people will experience legal consequences. I am sure that they are already experiencing them today as a result of their criminal, inhuman activities. I'm also sure that if they have no conscience, then perhaps they sleep at night, but worry during the day. After all, while they are waiting for the ICC's decision, many of those who should be on this list are already being eliminated by our special operations forces. Not only about the next ones, you mentioned that time is running out. Recently, Dmitry Medvedev, the Deputy Secretary of the National Security Council, who replaced Putin as president, also spoke about this. He and Shoigu, who also has an ICC warrant, are manipulating the dirty bomb issue. What work is being done on new names for the ICC warrants? Whenever we talk to our international partners, we always emphasize that 6 arrest warrants under the ICC are only the beginning. We believe that all those more than hundreds of thousands of war crimes, crimes against humanity, and crimes of genocide committed by Russians on our land should be held accountable for these crimes. In particular, we are convinced that there should be many more arrest warrants from the ICC, not just 6. So we hope that the active work of the International Criminal Court on the situation in Ukraine will continue. The International Criminal Court works with the Judiciary and the Prosecutor's Office of Ukraine on a daily basis. We hope that we will actually see more arrest warrants from the ICC. However, we also have to understand that the ICC is not a mass justice body. The ICC will not take on hundreds of cases, but will focus on the big fish, the chiefs and commanders who gave the criminal orders. However, this does not mean that other criminals will escape responsibility. They can be convicted in the national courts of Ukraine, including in absentia. There are already such decisions, and they are ongoing. Or within the national judicial systems of those states that have opened criminal cases within their jurisdiction for war crimes and crimes against humanity committed by Russian citizens on the territory of Ukraine. Therefore, even if not the ICC, the judicial system of Ukraine and the judicial system of other states will be able to reach the perpetrators and inspirers of such crimes on the basis of the principle of universal jurisdiction. You have mentioned that the jurisdiction of the International Criminal Court does not cover the crime of aggression, so a special tribunal must be created to punish those who give orders for an aggressive war. What is the stage of the process of creating this tribunal? What formats are being considered? Only the military command or other persons who carried out orders? This will be a large-scale body that will bring to justice all representatives of criminal Russia. The fact is that indeed, when we talk about the most serious international crimes, we are talking about 4 categories: the crime of genocide, crimes against humanity, war crimes, and the crime of aggression. The crimes of genocide, crimes against humanity, and war crimes can be tried by the International Criminal Court, as it has jurisdiction over Ukraine. However, the ICC does not have jurisdiction over the crime of aggression and will not have jurisdiction in the near future, so a special tribunal should be established to try Russia's top political and military leadership. What is a crime of aggression? This is a crime against peace, a crime of starting and waging an aggressive war. If a person is judged for the crime of aggression, they are judged for everything related to this war and for the very fact of its beginning. About 80% of the sentences of the Nuremberg Tribunal concerned the crime of aggression, which was then called crimes against peace. So we are convinced that we should talk, of course, about responsibility for the crime of genocide, crimes against humanity, war crimes, but we should also not forget about responsibility for the crime of aggression. That is why we are working with our partners, a coalition of core groups consisting of 41 states as of today and several international organizations to create a special tribunal for the crime of aggression against Ukraine. The work is ongoing, and while it's happening at the legal level, it's mostly behind closed doors. This is a very serious, high-level legal discussion involving leading government lawyers from these 41 states and several international organizations. You know that the Council of Europe, as the largest European regional organization, is active. At the end of April this year, the Committee of Ministers of the Council of Europe instructed the Secretary General to prepare draft documents for the establishment of a special tribunal, including a bilateral agreement between Ukraine and the Council of Europe. We believe that the establishment of the tribunal on the basis of this agreement is the best option. We are moving forward, and we will definitely report on the specific legal results. This body will complement the International Criminal Court and national justice systems by ensuring accountability for the crime of aggression against Ukraine. We have the largest aggressive war, at least in Europe, since 1945. We believe that those who started this war, and for the very fact of its beginning, who are waging it, who are giving criminal orders for its continuation, must be held accountable for it unequivocally. It simply cannot be otherwise. The war, the largest in Europe, and obviously in the world that we are witnessing now, is being waged against us by the Russian Federation. We are fighting back against this country, in fact, its army of millions. But the state leadership and senior officials, as far as we understand, can be considered immune. How this immunity will be overcome through the newly created tribunal, through the newly created court, of course, these discussions are still ongoing. Ukraine certainly stands by its position that no immunities should be applied for the crime of aggression against Ukraine. We are talking about two categories of immunity: functional, for any official, and personal, for the head of state, government, and minister of foreign affairs. Functional immunities of officials should not obstruct the activities of the special tribunal. As for the personal immunities of the current Troika, Ukraine insists on their non-extension. We are confident that together with our international partners, we will find a legal formula to bring all of them to justice. Who is guilty of committing the crime of aggression against our state. Some lawyers believe that it may be incorrect to punish ordinary soldiers, such as tankers or pilots, because they had no influence on the outbreak or duration of the war. However, they did follow military orders and did not refuse them. To what extent is this also a moral boundary, or is it still a legal one? I believe that the highest political and military leadership of Russia should be held accountable for the crime of aggression. To what extent will the future special tribunal determine this? There may be about 20 people who were directly involved in this criminal plan. This does not mean that all other Russian soldiers and officers are immune or will not be prosecuted. Not at all, because they should be held accountable for other categories of international crimes: crimes of genocide, crimes of inhumanity, war crimes, as well as other crimes, for example, under the Criminal Code of Ukraine, which they commit on our soil. The backlash of the possibility of legal conviction of such persons, their criminal behavior, is significant. I think there are many opportunities to ensure justice for their criminal activities. When we talk about the crime of aggression, we are talking about the top political and military leadership of the state. But this does not mean that we forget about all those thousands, tens of thousands, hundreds of thousands of Russian criminals who commit war crimes and crimes against humanity on our territory. They must also be punished. They must be held accountable, not for the crime of aggression, which is an elitist crime, but for other crimes. There are enough opportunities to ensure such accountability. It's great that 41 states are helping us, as I heard, to create a special tribunal and develop its model. The Council of Europe is powerful, more so than others. There are some states that can somehow put up legal resistance and put spokes in the wheels. Is it not important? I would not like to talk about spokes in the wheels. I would simply say that the issue of creating a new justice body that has not existed for 80 years is important. The last international tribunal that had jurisdiction over the crime of aggression was the International Military Tribunal in Nuremberg. That is, to create such a body for the first time in 80 years is not an easy task, and it requires time and effort. Of course, there are states that have their own point of view, their own vision, their own legal tradition, and we need to find a common denominator, without, of course, giving up our key positions. But I am confident that in the end, we will be able to create an effective, legitimate special tribunal. Therefore, I would not like to talk about any spokes in the wheels or problems. On the contrary, I would like to say that we and our partners are committed to constructive and to find the most optimal way out of the situation, in accordance with the creation of the most effective special tribunal. On September 23rd, hearings began in The Hague on Ukraine's 2016 lawsuit against Russia for violating sovereign rights in the Black and Azov Seas, including the Kerch Strait, where the illegal Crimean bridge was already operating. In The Hague, Ukraine proposes to demolish the Kerch Bridge, which has no right to stand in the water. From September 23rd to October 5th, the hearings were held in a closed format. Is it possible to find out the details of the hearing? What is the progress in the case, and what are the next steps, given that Russia continues to violate the rules in the Black and Azov Seas? The case was heard in an arbitration tribunal, established in accordance with Annex 7 to the UN Convention on the Law of the Sea in the Permanent Court of Arbitration. According to the rules of procedure of such proceedings, the hearings are confidential, i.e. closed to the public and the press. Accordingly, this is a significant difference from the hearings at the International Court of Justice, where all hearings are public and anyone can freely access them via the internet, online broadcast, or recording. This is a feature of such hearings, and only the first day, part of which is devoted to opening statements by the agents of the states in the case, and the last day, when the closing statement of the state agents is made, are open to the public. These speeches, the first and the last, were broadcast on the website of the Permanent Court of Arbitration, so they were available for review. We also made comments within the framework of these hearings, exclusively in the format of the first and last days, since everything else is again confidential, closed to the press. Therefore, we ask for your understanding in observing the relevant rules and procedures that apply in this type of international arbitration tribunals. Yes, of course, we are in this case, and again, we openly said on our first and last day that the Kerch Bridge is illegal a priori as such. So, accordingly, it should not exist, and in order not to continue all the violations that it has generated, including the freedom of navigation in the Kerch Strait from the Sea of Azov. Despite the temporary occupation of the Azov Sea by Russia, we will regain control of our territories, so freedom of navigation in the waters is critical for Ukraine. Large-class ships such as Panamax, Handymax, and Handysize cannot pass through the Sea of Azov because of the low Kerch Bridge. Which is the lowest bridge over the international strait. This bridge poses serious threats to the environment of the waters and the underwater cultural heritage that has been preserved here for thousands of years. Ukraine says Russia violated the law of the Sea Convention. In the context of violation of freedom of navigation, the right to a clean, natural marine environment. We look forward to the decision of this International Arbitration Tribunal. Our partners and colleagues also agreed that the Kerch Bridge should be demolished, understanding why it is not needed there. I cannot say what decision the International Arbitration Tribunal will make, but Ukraine's demand is quite natural. The status of the Azov Sea is also an important issue in the case. The Russian Federation considers itself the only littoral state in the Azov Sea after the events of September 2022, which is completely unacceptable. We are talking about the fact that the Sea of Azov is essentially a sea covered by the UN Convention on the Law of the Sea, where there are spaces such as the territorial sea and the exclusive economic zone. And the Russian Federation cannot simply appropriate and make its internal waters the largest territory that could ever be recognized as internal waters in the history of international maritime law. So let's hope that the International Tribunal will hear Ukraine's arguments in this matter. But again, we are waiting for the decision because, once again, according to the rules of procedure of such tribunals, the hearings are confidential, and therefore, of course, we as representatives of the state in the case cannot disclose many things until the decision is published. We definitely understand all of this. Great. Thank you for explaining it again. And Mr. Anton, could you please tell us what other cases are pending? What charges against the Russian Federation can be brought to the International Criminal Court? What are we working on? Well, the work is ongoing, and it is a constant communication, as I said, between the Prosecutor's Office of Ukraine, in particular the Office of the Prosecutor General, and the International Criminal Court. We hope that there will be more arrest warrants issued by the International Criminal Court against Russian citizens. This also includes the case at the International Court of Justice on genocide charges, which has moved to the stage of consideration of the case on the merits. We also have a case before the International Tribunal against the Russian Federation, as well as cases before the European Court of Human Rights, interstate cases between Ukraine and the Russian Federation. This also includes work on a special tribunal for the crime of aggression against Ukraine. Ukraine is working hard to establish an effective and legitimate tribunal, as well as an international compensation mechanism for reparations for Russia's violations of international law during its aggression against Ukraine. These are also so-called diagonal disputes. when Ukrainian companies file lawsuits in investment arbitration against the Russian Federation as a state that has violated their rights. In other words, this legal part of countering Russian aggression is multi-vector, and we hope that it will lead to the Russian Federation being found guilty of its violations of international law. Earlier this year, the International Court of Justice found that Russia had violated the UN Convention for the Suppression of the Financing of Terrorism by failing to investigate the facts of terrorist financing on its part. It also found that Russia had violated the International Convention on the Elimination of Racial Discrimination. By destroying Ukrainian education in the occupied Crimea after 2014. This case and these two rulings are important because it is the first time that the Russian Federation has been recognized by an international judicial body, an international judicial institution, as a violator of international law. We hope that decisions in the development of these rulings will necessarily take place in future cases, and we hope so too. We have mentioned the Nuremberg trials today. We have done so many times. On October 16th, I mentioned the 78th anniversary of the execution of the main criminals of Nazi Germany under the Nuremberg trials. They walked 13 steps to the scaffold, and Russian criminals may also face a similar fate. Today, international law does not allow the death penalty. But I think there are enough options to make these people feel responsible. I thank you, Anton, and all our diplomats, as well as the countries that help us. Thank you for the conversation. We hope that there will be time to continue this topic. Thank you for your work, position, and time. Thank you. Anton Korynevych, Ambassador at Large of the Ministry of Foreign Affairs of Ukraine. I, Iryna Uzlova, spoke with him. Leave comments, draw conclusions, believe in the armed forces. See you, and let's win.